Someone with an abundance of real talent in the last 50 years is American singer Cher. I hadn't heard of her either until beginning this subject, but it only took a few short hours of YouTubing her playlists to see how amazing she is. Anyway, in 1995, an Australian company called Raben Footwear seemed to agree with me on this, and so imported 1,000 copies of a CD manufactured by the Pilz Media Group of Germany. These CDs contained sound recordings by the incredible Cher, the copyright of which was owned by Polygram. Now, a copyright is a series of exclusive rights over the expression of ideas in material form. In Australia, another company was the exclusive licensee of Polygram's sound copyrights. This means that this other company was given the right to commercialize the intellectual property, in this case Cher's sound recordings, to the exclusion of all others. Now here's the important part. Before importing the CDs, Raben wrote to Pilz the following, quote, "Would you also confirm that all license and copyright conditions have been met for sale and distribution in Australia and New Zealand?" Unquote. Mr. Kilch of Pilz Media Group responded with the following, and I paraphrase, "Regarding copyrights and licenses, as you have in Australia an institution which is called AMCOS, you will have to notify them about how much mechanical copyrights you may have to pay in Australia." AMCOS stands for Australian Mechanical Copyright Owners Society, and mechanical copyright is simply legal jargon for the copyright of the underlying musical works in the recordings. Now, Raben did not follow Mr. Kilch's instructions and proceeded to sell 55 of Cher's CDs. That is, before both Polygram, now the respondent, and the Australian licensee brought proceedings against Raben. On first instance, Raben was held to have breached sections 102 and 103 of the Copyright Act 1968 and was ordered to pay compensatory damages of $275 and additional damages of $15,000. The pertinent component of sections 102 and 103 stipulates that copyright is infringed if the defendant knew or ought reasonably to have known that the hypothetical making of that article in Australia by the importer would be a copyright infringement. Raben appealed the trial judge's decision on the basis of this component, arguing that they did not know or ought reasonably to have known as the sections prescribe. This is often referred to as actual or constructive knowledge. On appeal, all three judges agreed that the limited and guarded nature of Pilz's reply was more than enough for the directors at Raben to know, that is, to have actual knowledge that making Cher CDs in Australia would be a copyright infringement, especially notwithstanding approval by AMCOS, and therefore the importation and selling of the CDs without license was also in breach of sections 102 and 103. This, paired with Raben's testimony on trial that they were familiar with the copyright laws surrounding sound recordings, meant that Raben's appeal was unsuccessful. To summarise from this case, 1. To establish copyright infringement, Raben needed to have actual or constructive knowledge prescribed by sections 102 and 103 of the Copyright Act, that had Raben made the article in Australia, they would have infringed copyright. And 2. The limited and guarded nature of Pilz's letter to Raben was sufficient for Raben to have had at least constructive knowledge in this regard, and therefore Raben has infringed copyright.
Created using Powtoon.